have to start because we're already delayed 14 minutes. Let's say welcome again to the ISACA Square Tables, our weekly webinar hosted by ISACA Netherlands chapter, also sponsored by Nuria, the Dutch Auditors Association in the Netherlands. Today holds the first part of our mini series of two parts about standards, hackers, and lawmakers. And we do have very exciting and let's say very experienced speakers. But before we go forward with that, some housekeeping rules that we need to go through. Make sure that you appear on the Microsoft Teams with the same first name and last name that you have registered. This is particularly for people seeking the CPEs. Tonight, the presentation is going to be 120 minutes almost, so it's 2 hours, and it will be recorded. The slides might be released by email after the session. Once you join, please make sure your microphone is muted and stop sharing your video camera because that affects the overall quality of the meeting. And if you have any questions, please raise your hand. Usually the raise hand button is next to the participants chat and is the third one. Or if you're looking from left to right and from right to left, it's going to be after your leave meeting, share and mute and video. And the more actions, this is going to be the fifth one. Without further ado, I want to give the chance to our speakers today. So I think, Michael, you're going to start. Please share your screen and kick off.
Yes, guys, I was asking if you or Yana can share the slides.
Oh, yeah, sure.
It's not the screen, it's slides. Okay. Next slide. Okay, hello everybody. My name is Michael Petrov. I represent this course. We are going to have very tight schedule. Usually we teach this course in the US and we spend 9 hours, and we will have to squeeze everything in 4 hours. But the good news is all the materials will be available, and we are open to talk and connect after and share ideas. The thing is that the goal of this course is not to promote any technology or any vendors. We will be talking about techniques. We will be talking about practical advices, how we implement cybersecurity standards, and how we're trying to standardize implementation of cybersecurity standards in traditional environments and public cloud environments. We jokingly call it standards versus hackers and lawmakers because we feel that we as cybersecurity and compliance professionals, we have to defend our clients from lawmakers and law enforcement as well, because cybersecurity is not cybersecurity issues may create financial and reputational issues, not only financial issues, but also financial losses, not only from hackers but also from the government. Next slide. A little bit about Digital Edge, again, not to promote, just to say who we are and to share our experience. We are more than 25 years in the business. We're global. We have offices in the United States. We have Panama. We have Europe. We have office in Ukraine. We have office in Armenia, and we have people in India. Our motto on the business side, we say nothing is too simple, nothing is too complex, meaning that even simple tasks should be taken with good diligence, and nothing is too complex that we can handle tasks of any complexity. Our largest client is global bank, one of the largest in the world. And our smallest client would be, I don't know, could be one person lawyer, law firm, or one person company. We we are um, basically, when we work with clients, we take full responsibility for cybersecurity in compliance. It's in our DNA, and we teach our clients to use the same idea that their infrastructure, their environment should be built with thought about compliance and possible automation of compliance requirements from get-go. And we don't, so you don't need to do any extra steps to stay in compliance. Next slide, please.
Oh wow.
Uh, cybersecurity compliance, we say that it has basically left brain and the right brain, because something it's like very technical, but something it's really art, because certain things like risk analysis, it's more like your experience. You cannot. We will show and we will argue, and we wanted to hear your opinion as of now, and we know kind of like a fair approach when the risk could be calculated. We say that in cybersecurity we cannot calculate, so it's more like an art. But certainly there is a lot of technology in our profession, so we say that people in our profession, they should exercise both brains, left and right. Uh, Next slide, please. The landscape changes rapidly, not just because of COVID, and hackers are constantly present new challenges. New frameworks are coming up. Clients are coming up with new ideas how to do things, and it's hard to keep everything tight. And I'm sure you see the same thing, that laws and regulations are putting a lot of pressure on cybersecurity, and we'll be talking a lot today about what you have to or we have to do about laws and regulations, and specifically about privacy. And it will be we will be touching a little bit on European laws and GDPR, but theme of this presentation is what we do in the United States to comply with United States laws. But I think ideas and practices that we're going to be showing you will also apply, and you would be able to use it in Europe. Next slide, please. So this is agenda for the day. Let's just skip it and go into the presentation, because we have short time. Next slide. Again, my name is Michael Petrov, Digital Edge. This is an image from our office in Panama. Just nice view. I really like that view. I'm going to be presenting most of the materials tomorrow, and for today we're going to be setting precedents for our presentation for tomorrow. So tomorrow we will be showing how we are expanding on certain standards and certain frameworks to cover more, to comply with certain legal requirements. Today, Keith will be presenting a legal framework in the United States, and he will be touching certain things for that will be applicable for European Union, but it's not necessarily we're like teaching the law. It's more to show what we are dealing with, and tomorrow we'll be showing how we actually, what techniques we are using to deal with those laws and regulations. And then we are going to have a short presentation from Slava, who's CISSP and very experienced practitioner who was involved in many incidents and recoveries and eradication of bad guys. He has tons of practical experience. Again, today presentation is to set up a presence for tomorrow. We are totally open for suggestions. We are totally open for free discussion. If you raise your hand, you can unmute yourself and say, "Mike, you're an idiot. You don't do it right." I would be happy to debate it. and explain my idea. I mean, without insults, but I just wanted to have free conversation because there are a few things that are not typical. Like I have lots of arguments with Center for Information Security for uh, understanding of cybersecurity risks, and with ISO as well, because I think they are more understanding it based on the industrial understanding, and cybersecurity risks are totally different. So you could stop. You could. Yana will be watching the chat, and if you type in the chat, we will be able to discuss whatever is in the chat. So
Yeah,
let's.
Michael, allow me to interrupt you for a second. I just want to confirm to everyone what you mentioned about tomorrow is actually the next week, because we have this seminar on Wednesday, and the next portion is going to be on the next Wednesday, Wednesday 26th. I just want to confirm because we got a lot of questions about
Yeah,
tomorrow.
correct,
Sorry.
correct. I meant next session. Next slide, please. So we are saying that we are under constant attack from both from bad guys and from the government, and we have to analyze risks, and our risks are multidimensional. So it's not just to defend our infrastructures, but to make sure that we are not going to be getting hammered by government agencies. So we're going to analyze two sides of threats that exist in today's landscape. Next slide, please. And this section will be delivered by Keith. So I'm going to mute myself. Keith, take over the control, or Yana can read the slides. But Keith, the stage is yours.
Okay, thanks a lot, Mike. Hi, my name's Keith Barry. Jan, if you could just move the slide. Next slide. Hi, my name's Keith Barry. I am an attorney here with Digital Edge. I've worked in IT for over 10 years on the tech side. I have a background in the tech side. My undergraduate work was in computer science. I have several industry certifications, and I'm currently serving as the Vice President of Compliance here at DE. So if a company comes to us and wants to set up some sort of framework, a cybersecurity framework or system, or if they just have general questions regarding the law or some regulation, I'm probably the person they're going to come speak to, or I'm going to be advising the person they're speaking to. Let's just move forward here. Okay, so as Mike said earlier, this is sort of, this module is sort of meant as sort of the law from sort of an American perspective. We're going to be touching on European law as well, but again, it's sort of like doing business with American companies, or you're in the United States and you want to get an idea of what United States businesses have to comply with, or what they're up against, or how the U.S. thinks about cybersecurity. That's sort of what this this whole module is about. Just to get started, the U.S. is a very large country. As you know, it's got about 350 plus million people in it. It's been set up since the very beginning as a federal government, with sort of devolved powers to the various states. The federal government is what most people think of when they think of the United States government, because it is. It represents all the 50 states. Technically, they're not above state governments. They're technically supposed to be a government of limited powers, with most of the states having the general power to make laws. However, as history has unfolded, the federal government has become more and more powerful over time, thanks in part to its constitutional supremacy, to make laws that will override state laws. So if there's a conflict and the federal government has power to make a law in a certain area, it will override the state law, and that's sort of how it works. So again, the federal government may only make laws in areas that the Constitution says it can make laws in. States can make any law, but if there's a conflict, the feds win, as long as they are permitted to make a law in such an area. Next slide. Okay, so federal laws and regulations may apply to all companies operating within the boundaries of the United States. They are the main body of regulatory cybersecurity law within the United States. State laws apply, of course, only to companies operating within the bounds of a particular state. There are a minority of laws, but growing minority of laws, because we find ourselves in a situation in the United States where the federal government is not really taking the lead, at least from a privacy perspective. Now, whether or not a federal law applies to you or a state law applies to you will come down to a question of jurisdiction, which is not an easy question when you're dealing with the United States. Next slide, Yana. Right. So jurisdiction in the United States is difficult because it's such a big company, it's a big country. It has 50 different states. They all have their own legislatures. They all have their own executive branches. It's a gigantic bureaucracy, 50 gigantic bureaucracies within a super gigantic bureaucracy. The law, as far as separating the powers of each of the states and the power of the federal government and who can bring who to court in what state, is not an easy question. It's something that's generally that you really need an attorney to sort of figure out. It's similar to figuring out whether the GDPR applies to you, whether you're holding out to a specific state or if you're holding out to the United States. That's a question of law that has to be decided. It's if you're wondering whether or not a law applies to you in the United States, you should probably consult an attorney. It shouldn't take them all that long to figure out, but it's possible even that you could be, as a foreign company, you could come under the jurisdiction of a state law as well, or multiple state laws. So just keep an eye out about that. As far as the landscape goes in the United States, we're sort of all over the place right now. We're in a very intermediary sort of position. There's no GDPR-like all-encompassing law that's applicable to every company. Our laws are industry-specific, and they're scattered around, and there is not much sense to be made of how it's done. It's just sort of done. It's been done piecemeal, as needed. Generally, these laws are in the finance, healthcare, and defense industries. That's what you're going to find. I mean, there are other laws as well. There are generally applicable laws, to be sure. But the ones that are the most heavily regulated with the most detailed regulations are finance, healthcare, and defense. Now, that's not to say that there isn't any law that applies to all. There's no GDPR-like law that applies to all the companies within the United States, but we do have the Federal Trade Commission that does have reasonable security measures law. There's no privacy involved or anything like that, but it's just the need to have reasonable security measures is the FTC requirement, Federal Trade Commission here in the United States. And what they've done is they have taken for themselves over the years, and it's been a long time now, and nobody's ever seriously questioned whether they do have the right to do this. The FTC says that for you to not have, this is how they took power to enforce cybersecurity standards essentially on companies. What they're saying is that a customer reasonably expects you to have reasonable cybersecurity safeguards in place, and if you don't have those safeguards in place, it's as though you are deceiving the customer. right? That's how they look at it. The whole point of the FTC is to protect customers from dishonest advertising, false advertising, or any other sort of scam that may be taking place among businesses. So essentially, what they said is that if you don't have reasonable security controls, you're essentially scamming customers, and that's how they drew their power, and nobody has challenged it. So the FTC, with this power, is the main enforcer of all cybersecurity standards on the United States companies. Next slide. Okay. So U.S. laws and regulations can have mandates in one or more of the following areas, and this is more than just U.S. laws. This is global. Okay, you're going to have laws that are for reasonable security controls. You're going to have breach notification laws, and then you're going to have laws about privacy rights. Or you're going to have one law that has all three of those things in it, like the GDPR. All right. Security controls, right? Reasonable security controls. These are technical, procedural mandates that you must have in place. This is your firewalls, antivirus, IDS, IPS, your incident response plans, awareness training, all that sort of thing that goes into what you think of as a cybersecurity system. Breach notification. Every single state in the United States, plus the District of Columbia, that's 51 jurisdictions, has breach notification rules that have to be followed if, in fact, your company is within the jurisdiction of one of those states. And then there are privacy rights. Now, privacy rights in the United States, this is where you're going to find the United States the most lacking and trailing well behind Europe as far as implementation. The only real industries that have privacy rights would be, healthcare and finance. And, to be sure, our healthcare industry is well protected with personal health information. Our finance industry is somewhat well protected, but there is no all-encompassing set of privacy rights that are given to the citizens of the United States or to anybody else who is giving their data to United States companies. So it's here and there, and we'll get to that, and we'll talk about that a little in the coming slides. Next slide. Okay, so who are the enforcers in the United States? Well, it depends. It depends on what area of the law we're talking about. It depends if it's federal or state. Generally, the main enforcers are, as I said, the FTC, the SEC, the Securities and Exchange Commission, that deals with finance, and the Department of Health and Human Services, which deals with healthcare. And as far as state laws, it's almost always going to be the attorneys general for each state, their offices that do the enforcement for those state laws. The penalties for breaking the law, it depends on what law we're talking about. There are extraordinarily large fines that can be levied on you, especially by the FTC, but also injunctive orders and even criminal penalties. So it just runs the whole gamut. It depends what law we're talking about. It depends how badly you've breached that law. It depends how sensitive the information was in the breach and all these things. Next slide. All right, so the FTC, here we go. This is going through some examples here. Again, this is this is sort of the watered down version of this course. So I have to just I shrunk things down to just pertinent bits that you can easily digest in the hour and a half that I have to do this. So the FTC has security controls, breach notification, and privacy rights. And I say privacy rights, even though I said before there aren't any privacy rights. Well, that's true. Here's the thing. The security controls have to be reasonable. What exactly that means, they never really define. So it's like the GDPR and a lot of different laws where they just sort of say, well, what's reasonable? And you sort of take into account the size of the company, the sensitivity of the data you're dealing with, and the amount of money your company has, these sorts of things. And you sort of, well, this is reasonable, that's not reasonable. I mean, the truth of the matter is, if you do have a breach, and the FTC catches wind of it, and they want to bring an enforcement action against you, they're probably going to find something wrong with your cybersecurity controls, no matter how reasonable you think they are. The question is, what is the fine going to be? And the fine can be gigantic. What they do is they have a maximum penalty, and this year it's $43,280 American dollars for violation. Facebook was fined in $5 billion in 2019. That's $5 billion. It's absolutely gigantic what they can do. And here's the thing: certain healthcare companies must notify affected individuals. That's done, but generally that doesn't apply to anyone else except for certain healthcare companies. Privacy in the FTC is interesting. There is no mandate that you protect customer information as far as the FTC is concerned. There is no, I mean, you have to protect information, but there's no right to privacy. But
Sorry for this.
No, it's okay. But if there's a promise, if you say that you're going to be keeping your information confidential, you're not going to be giving it to spammers or whoever, then you have to keep that promise, or otherwise you're being deceptive, right? And that brings you within the core of the FTC Act Section 5A. So that's what Facebook did. Facebook, even though they could have sold your information to anybody on the planet they wanted to, they said they weren't going to, and for that they were fined $5 billion. And that's the FTC in a nutshell. Next slide. Okay, Graham Leach Bliley. Okay, so Graham Leach Bliley comes about. It's about this is a finance industry bill. It has to do, it mandates certain privacy rights and reasonable security controls. What they're saying here, this is a very common finance industry standard that a lot of financial institutions have to follow by. You have to have written cybersecurity controls in place to protect PII. So you can't go about saying, well, we do things and, you know, it's all just sort of word of mouth or something like that. It has to be written down. It is somewhat specific. And then you have to give notices to individuals if PII is shared, and the individuals are allowed to opt out of sharing. And that's really the extent of the privacy rights that are granted here, is that you have a right to opt out of sharing. And that's pretty much it. Max penalty is $100,000 per violation. And when I say per violation here, I just highlighted the per, just to let you know that these things are aggregate. Okay, so if you have, you have 10 violations, that's $1 million, right? So it can add up, and that's what happened to Facebook. That's why Facebook was $5 billion. It was $43,000 times, however many people, and that's how they wound up at $5 billion. So it's not just one transactional violation that might happen. It's all your violations per person, right? So if you violate, a lot of people's rights, they're just going to keep adding up to $100,000 and keep going. There's no cap. The thing that keeps these government agencies, and I kind of know this because I briefly worked in the Federal Aviation Administration, and the thing that sort of the only thing that really keeps these fines down is the government's interests in not destroying businesses. So the federal government just has so much power. It's the most powerful government on the face of the planet, and they know that. And so it's really up to them how much they want to hurt these companies, and it's really just up to them, whether or not they want to destroy a company, and that's really it. So you got to be really careful. The only thing stopping them is them, as far as how far they want to go. Let's go to HIPAA now. Now HIPAA is probably, well, it's not probably. As far as the federal level goes, anyway, it's definitely the most comprehensive of the laws we have in the United States. It deals with the healthcare industry. It deals with PHI, which is PII, containing health information, right? So PII, right, is anything it's personally identifiable information, right? As we know it under the GDPR, and as it's generally known, it doesn't have to. It technically doesn't have to be sensitive information. It just has to be personally identifiable. Well, here in HIPAA, they use PHI, and that is PII. That contains rather healthcare information. So it's personally identifiable information, and the information itself is health information. So it's highly protected. Reasonable security controls have to be in place. There's a breach notification or rule in there within 60 days. If 500, this is sort of interesting. If 500 individuals are exposed or more, you have to notify prominent media outlets, which is really interesting. This could be very damaging. Just from a PR point of view, there has to be prominent media outlets. So you can't just go to some local newspaper in some small town in New York and say, "Oh, well, we published it." No, it has to be prominent media outlets. Everyone has to know about it. PHI is not shared unless certain circumstances are satisfied. Generally, this is going to be if it has to be shared with an insurance company and a hospital or something like that, or you got a healthcare provider, doctor. Your regular doctor has to share it with another doctor at a hospital or something like that. There's also rights that individuals have to access and control information that are similar to, but not quite to the level that you would find in GDPR. But it's still, I have to say, a pretty robust legal framework here to protect health information. It's enforced by the Department of Health and Human Services. The penalty here, which is interesting, is actually not. Let's see here. Why is this? Oh, this is blocking me. I apologize, guys. It's actually 1.5 million in a year. That's as much as they can fine you, but it's 50,000 per violation. So it's aggregate, yes, but they cap it at 1.5 million in a year. And it's an older law at this point. So I don't think there's any changes. I don't know of any changes on the horizon or anything like that, or upping the cap, because that sort of seems to be in vogue these days. But anyway, that's it. You got a lot of rights, but the actual penalties are not as bad as they could be under, like, say, the FTC. Next slide. Yana, next slide, please. I think we may have lost Yana.
That would be James. Just a second. Trying to see if she's on mute.
Here, do you hear me?
Yes. Can you?
Hi, Yana.
Screen?
Yana, can you share again? I apologize.
So, meanwhile, while Yana returns back, we have a question coming through the chat. Is there much of an overlap between Gramm-Leach-Bliley Act and Sarbanes-Oxley? So maybe we can take that question until we get back the slides.
Yeah, well, look, I mean, Sarbanes-Oxley came about. They sort of address two different things, but yeah, I mean, there is overlap. There's overlap as far as who they apply to. Sarbanes-Oxley came about as a result of the financial crash that we had, well, the bubble, the dot-com bubble back in 2000. And what was happening is that people were going into their systems and they were changing the numbers around, right? They were cooking the books after the fact. And so Sarbanes-Oxley is a far more well, actually, we're getting Sarbanes-Oxley now. Look at that. Is actually a lot more harsher punished, right? It's a much harsher punishment with Sarbanes-Oxley. It's criminal. You're looking at possible criminal, prison terms or Sarbanes-Oxley. It's not just it's not just fines there, right? So one has to do, if as far as Gramm-Leach-Bliley, has to do with just making sure you have some sort of framework, a reasonable framework, that you're taking some steps to control sensitive information, right? Sarbanes-Oxley is more concerned with you're not trying to commit fraud, right? So yes, they both relate to reasonable security controls. So in that respect, yeah, there's overlap because they both have security controls requirements that are reasonable, and and they're going to be about the same thing, right? So if there's an enforcement action brought to you under Sarbanes-Oxley or the Gramm-Leach-Bliley, given what your company does, the sensitivity of data, the size of your company, it's going to be essentially the same controls that are needed under each of the acts, right? Because we're just talking about reasonable cybersecurity controls in place. When it comes to that, most laws are very vague on what exactly that means. So they essentially mean the same thing under Sarbanes-Oxley and Gramm-Leach-Bliley. The thing with Sarbanes-Oxley is that the company has to control the effectiveness, report the control effectiveness to the SEC, and those are more than just cybersecurity controls. Those are controls throughout the organization, just corporate financial controls, and they have to certify that they're complete and accurate. And if they lie, the CFO, CEO can do 20 years in prison if it's willful, or a mere 10 years if it's not done willfully. So you could get 10 years in prison under Sarbanes-Oxley, even if you accidentally filed a full certification. So it's serious business, Sarbanes-Oxley. People have been prosecuted under this. People have gone to jail under this law. But yes, I mean, in the sense that they overlap because they're both for reasonable cybersecurity controls. There is overlap. Is someone talking or? Oh, okay. So that's Sarbanes-Oxley. Thanks for bringing that up. But yeah, there is a lot of overlap in what's required. Absolutely. DFARS, Defense Acquisition Regulations. Now, I include this because if you're a big government contractor in the United States, if you're Boeing, defense contractor, you're Boeing or you're Raytheon or one of these famous defense industry, Northrop Grumman, you're going to be well aware of how to handle confidential information, and you're going to know all about that, and it's going to be well established what you have to do with all the information that you receive. But other companies that aren't so well known or aren't so defense oriented, or perhaps you work in the supply chain of such a company, will still have to come under these DFARS, these Defense Federal Acquisition Regulations. Common in the United States, the companies have to deal with this if they're in the supply chain of some sort of defense contractor. It's just security controls, again, reasonable security controls, breach notification. What's interesting here is you see this reference to NIST, National Institute of Science and Technology. Now, NIST is and Michael will be talking about this at your next module. NIST is a governmental entity that exists just for creating standards to be used by the federal government. Okay, the federal government has a gigantic framework that you can use called NIST. Okay, the NIST 800 is the most well known. There's also other frameworks that pertain to cybersecurity that are smaller. They're subsets. If you're ever doing business in the supply chain with a defense contractor, you would follow one of the subsets of NIST to protect unclassified defense information, which is a particular type of information. It's not quite classified, but it's sensitive information. So if it's sensitive in government information, even though it's not classified, you still have to protect it. And that's what this has to come down to. You should just be aware of it. The enforcement on these is really just contractual termination of the contract. They could sue you for whatever the damages are, that sort of thing. You just lose business. But you should be aware of that. Mike will get more into NIST. NIST is not any sort of national mandate. It's for companies in the United States, non-defense oriented companies often use NIST. Not because they're mandated to, but just because they want to, because it is a very robust cybersecurity framework, very large, very robust cybersecurity framework. But again, it is not any sort of mandate on companies or anything like that to use the NIST framework. I guess that's what I would just want to say about that. Next slide.
Keith, there is a coming interesting question through the text. So what about attempts to integrate all these laws into one maybe or something to reduce legal complexity? Is that something that's being discussed maybe at the Senate or the...
Right. So there is currently a law from 2017. There is a law that has been put into Congress in the House of Representatives. It's still in committee. It's been there since 2017. It is like a GDPR divided by 100. Okay, it's a very weak form of GDPR, or a relatively weak form of GDPR, and it is, from what I know, not going anywhere. I mean, it's not even I don't know of any plans for it to even get out of committee at this point. It's not really on anyone's radar, to be honest. At the moment, we have a lot of things going on from a political. I mean, it's in the political realm now, right? I mean, these are politicians, and cybersecurity. While it's important and it's a known issue from a military point of view or from like a strategic point of view, the privacy rules are not so much, a very political hot topic right now at the moment. And that's sort of what it deals a lot with, though it also has reasonable cybersecurity control mandate, just like the GDPR. It has all the things GDPR has, just not as many of them. It has the three different, it has privacy rights, it has reasonable security controls and breach notification, just easier to implement than GDPR. But again, nobody's really pushing for it. It's not in the news. I wouldn't expect anything to come of it for a while, though anything can happen. The current political situation in the United States, you have the Democrats are in power in both the Senate, the House of Representatives, and also the executive branch embodied in the president. So if it was going to happen, this would actually be the easier time for it to happen, because just that party would be more inclined to implement such a law on the states. But I haven't seen anything about it being pushed or anything like that. So I wouldn't hold my breath, I guess is what I'm saying.
Yep. Thank you for that answer. We have another quick question about actually the SCRMS 2 decision and its effects on the relationship with the U.S. laws.
I'm sorry, could you repeat that? I couldn't make out what you said.
The SCRMS 2, as you know, there was a European Court of Justice issue.
Oh yes.
Say,
okay. Yeah. Okay. Yeah. So okay. Right. So as I'm sure you guys might have known, and this actually I get to later on in the module, and hopefully we get to it. But to be a processor of EU citizen data, there's what is like five. I think there's 4 or 5 different ways you could do it. One of those ways is to have some sort of agreement that you follow, and that you're going to follow certain standards. And the United States had one agreement in place with the EU, and that was struck down because of the United States government spying. And then now there was another one, and that too has just been struck down because of the United States spying. Well, look, the thing is, when they fixed the first problem, right? They didn't really do anything that the Europeans were worried about, right? They're worried about the CIA and the NSA, and God knows how many other private entities that are out there spying on people all the time, and nothing was done to address that, right? And I got news, and to be honest with you, I can't imagine anything is going to be done to address that anytime soon. Just given the political winds here in the United States, and just the Patriot. I mean, ever since the Patriot Act, the United States has been on a very privacy unfriendly footing ever since 9/11. I don't see that changing anytime soon. Again, were it to change, we do have the Democrats who would be the ones who would probably, agree to protect at least EU citizens' data in that manner. But I really don't see that happening, anytime soon. I haven't heard of anything like that. I honestly can't imagine there's ever going to be a successful agreement between the EU and the US for that. So companies have to just take it upon themselves and abide by one of the other methods to be able to process EU data. But I guess the answer is no. There's nothing. I don't foresee that happening. There's nothing to indicate that the United States government is going to relent on their gigantic spying apparatus.
That's why I would like to follow up. Maybe the question wasn't coming from me. I was just relaying it from the chat. But from my side, when you mention Patriot Act, that causes a lot of let's put it, debate. Is a good word,
right?
Because after also the Snowden revelations, or what is called Snowden revelations, I don't want to be taking sides. The discussion is like, is that all stemming up to the Patriot Act, or it's stemming from other acts? And also, does that mean privacy by default is not a given within the US for non-US citizens?
Well, no, that's a good question. And look, and where does this? Okay. So the United States has an entire section of constitutional law that deals with privacy rights, right? It's built into the Fourth Amendment to the Constitution. You do have privacy rights, but it's a qualified right. The way that's always been looked at is, the big question is whether somebody has, the way it gets past the Constitution, looking at it from a foreign versus a domestic person and treating them differently for these purposes isn't really the issue here. Okay, a foreigner will usually have the same rights as an American citizen under the Constitution. Not always, but sometimes. But usually they do, unless there's national security concerns, which of course there are national security concerns here. But even if it was an American citizen, the question you ask is whether there is an expectation to the right of privacy in what you're doing, right? So it's all based on case law and what the courts have said you have an expectation of privacy to, right? As far as the Patriot Act goes and these other sorts of things, I mean, a lot of power was drawn from the Patriot Act. The Patriot Act relies on executive power essentially in times of war, or not necessarily at war, but just matters of national security. The president, as the commander-in-chief, has very broad authority as soon as that comes up. So you have all these rights, right? United States citizens and even European citizens that are here in the United States, or even European citizens accessing things here in the United States, right? I mean, should be protected generally. But once you trip that trigger of, if it's a matter of national security, then the executive has a lot of rights. So that's under the Constitution. The Patriot Act sort of just codifies the rights that the president has under the Constitution when dealing with foreign threats, right? So yeah, I mean, it gets murky. Not all the things that they're doing, from what I understand, are always 100% legal anyway. They're usually not found out what they're doing. Nobody really knows for sure the extent of the spying that they're doing. But yeah, a lot of it does come from, you could say it comes from the Patriot Act, but really it comes from the executive power in the Constitution that's given to the president for dealing with enemies over, outside our borders.
But Keith, I don't want to take a lot of your presentation time, so I'm going to ask this, and if you feel like it takes a lot of time, we can skip the question.
Sure.
The main reason I'm let's say mentioning the Patriot Act, and thank you so much for being frank and honest with your answer, is the fact that it allows for manufacturers of technology within the US to implement, let's say, special features to allow the overcome of security controls. And this is where a lot of us, on the personal level as well as on the maybe professional level, are a bit concerned that there is a statement that allows US to go and ask companies like Apple, like Microsoft, like others, to put a special backdoor. And that's where the line is a bit hard to understand.
This is a constitution, right? So this is the thing. Everyone's just Patriot Act. Patriot Act really doesn't give the president, the executive branch, any more power than it already has in the Constitution, right? It's just sort of codifying it and then sort of giving a stamp of approval by the Congress, which is fine. And theoretically, if anything, it would limit slightly the rights technically that the president would have. The thing is, the courts over the past 40 years, about 40, 45 years, when it comes to executive power in the foreign arena, they've been very lenient with what the president decides is necessary to do to protect the United States. So the law is not that the president or the executive branch, because anything that like the NSA, CIA, these are all executive branch agencies. This is all really the president of the United States doing it. The president of the United States is at the top of this section of our government, right? So the president can't do whatever he wants and just say, oh, well, national security. But he can, as a practical matter, he can pretty much do what he wants and say it's a matter of national security. I know that doesn't really make a lot of sense, but the powers are so extremely broad that the president has in times of war or in times of any real threat to the United States, terror times, things like that, that essentially the president, if he says, this isn't the law, and I'm not saying it is, but I'm saying it's a practical matter, just being very blunt. If the president says that there's a security threat and he could put up a reasonable argument that there is a foreign security threat, the president of the United States can do a lot of things as far as evasion of privacy goes. So, that's where that comes from, right? It's about, and if you were to challenge it in court, in the Supreme Court, the highest court in the United States, really all the president would have to do is just show some sort of rational reason for doing what he did. And if that rational reason is, oh, well, we heard there were, terrorist plots going over, being held in this system or something like that, he's probably going to be allowed to do it. All right. I don't know if that answers your question.
That's a great answer. And I want to take more than this from your presentation. But does the executive orders end with the presidency ending? So
no.
It doesn't.
No. So the executive, right? So the executive orders can last forever. Okay, but the next president comes in can simply quash the previous president's executive orders.
So practically, if let's say President George Bush, the father, not the son, did an executive order, and none of the consecutive presidents did remove that stays in power, right? And that
correct.
Stays.
Okay. Yeah.
I just understanding succession and how it works.
Mhm.
Thank you.
Yeah, and look, and the composition of the Supreme Court is also a huge issue right now in the United States. It's currently, there's 6 conservative justices, there's 3 liberal justices, right? So, there's a certain way of interpreting the Constitution that's, that's getting the majority vote right now, right? If it was if the composition was 6 liberal justices and 3 conservative justices, well, the president would probably have to show more for them to say it's okay to conduct, whatever action it is the executive branch is looking to conduct. All right. I mean, and look, this is all sort of real politics, sort of, stuff, right? This isn't, this is just sort of as a practical matter. I'm just trying to be very straight with you and very blunt. All right. Anything else?
No, go ahead, please. Go ahead.
Okay.
Please.
So
Thank you
the
so
next, yeah, sure, no problem. So the next one is the Children's Online Privacy Act. This is really just a warning for you guys to just stay away from collecting any sort of metadata at all on kids. It's a requirement for security controls and privacy rights. So you have to get actual parental consent before collecting, using, or disclosing PII of a child under 13. Now, they could have just come in and said, well, you can't collect any information on a child under 13. They chose not to do that, and I suspect it's for if there was some sort of marketing test or some sort of testing of what children like. Well, that you could still do that now as long as you get parental rights. But from a practical point of view, if you're putting out content for children like cartoons, it has to be like content that's actually geared for children. It's not generally applicable, or if you're putting out just general content and children happen to go on the site, you can collect that information. But if you're gearing it towards kids, if there's cartoon characters involved, if there's let's say famous people that are known to be popular with children or something like that, you're actually gearing towards kids. You have to get the actual parental consent from the parent, and so you would have to actually, and the level of consent is not just like, oh, I agree that I'm the parent, and click here. No, it would be something like a DocuSign, where the parent would actually agree via DocuSign that their particular child is you're allowed to collect data on them. So I would just stay away from that. The max penalty is $43,280 per violation, as is normal with FTC violations or FTC controlled regulations. And I tell you right now, I mean, from a political point of view, no one's going to feel bad for you if you violate this one. So I would just stay away from that altogether if I was you. FINRA, the next one here, this has to do, now in the United States, I don't know exactly how, I don't know if they do this in the Netherlands. This is more of a common law sort of country thing, I would think. But what we have are these semi-governmental agencies. They're private entities, but they're given sanction by the government to be in control of licensing, right? Like a bar association here in the United States. Like the New York Bar Association would be a private entity, but it's given it's given the right to control licensing of attorneys, right? So this has to do with people who are traders and stockbrokers and brokerage companies. And the main thing here that's interesting with FINRA is the security controls have to be in place. Really, the main mandate is retention. It has specific retention policies, but also interestingly is it mandates a warm implementation, a write once, read many implementation, so that you can't go in and start playing with the numbers. FINRA is a dangerous one to play with. They do have guidelines for violations, which are quite reasonable, but they never ever follow those guidelines. So it's an unspecified dollar amount. Wells Fargo got fined $4 million for failing to maintain an adequate worm implementation. So they'll go into the millions, no problem. Even though technically it should be hard for them to do so. they don't. They just be very careful if you're ever dealing with a company that comes under FINRA jurisdiction. Next slide. Okay, so the next one is the states. You may find yourself dealing with a company, you know, or dealing with clients that are in a particular state. New York State has a shield law, which is basically a reasonable data security requirement and data breach notification. It's pretty, you know, it's pretty straightforward. It's pretty simple. It's just, you know, protect private information, and then private information really means PII. Go to the next slide. Right, so you have to have, you know, and what's good about here, I'm just going to take you through this because this is sort of like how a lot of laws work when they're talking about reasonable security measures, is they'll say you need to have reasonable administrative safeguards, designating a security coordinator, identifying foreseeable risk, which is a risk assessment, assessing sufficiency of safeguards, there's a gap analysis, security training for employees, it's awareness training, and safeguards and contracts. This is vendor controls, right? So all these things are administrative safeguards. And then you have to have reasonable technical safeguards, right? And this all comes under the rubric of reasonable controls, right? So you have to assess, if you're doing software design or network design, you have to assess the risks. You have to have, you know, antivirus and all these sorts of things, malware prevention, firewalls, key controls, all that sort of thing. And then reasonable physical safeguards, which is becoming less and less relevant to most people outside of their home office. But, you know, and usually this is put on, I mean, these days, you know, so many things are in the cloud. It's usually handled by the, Mike's going to talk more about that, by the Amazon or Google or whoever's controlling your cloud. But, you know, if you do have a physical site, you have to have, you know, protections for people who may, you know, accessing the site or, you know, being escorted around a site, that sort of thing, making sure that your data is, that your equipment is protected, that it's cited properly, that there's UPS, this sort of thing. So that's really it. Administrative, technical, and physical safeguards, right? Those are the three types of reasonable security controls that you would have in place under these reasonable controls mandates in the various laws, at least in the United States and really everywhere. Next slide. Okay, and this is just a standard breach notification rule. If there's ever a breach, you disclose the breach of any New York State resident, et cetera, and you know, it'll just tell you who to report it to, the Attorney General, when to report it. New York, it's the fastest time possible, so they sort of leave that open, but that's it. Sometimes it's like a 72 hours, sometimes it's a 60-day breach requirement. They do allow you out off the hook here in New York if the disclosure was inadvertent and the business concludes reasonably that the info will not result in harm. So it's a pretty weak one, but it's typical of United States breach notification laws. Next slide. Okay, this one here is in California. Okay, this just came out as well. It's like the Shield law. It's more detailed. And in California, they're actually handing out individual privacy rights just as the GDPR does. Again, they just say you have to implement reasonable security procedures and practices. So reasonable security controls. Again, we see this. And again, we see that it's not really clearly defined what that is. They don't mention any particular framework. They don't mention any particular controls or any really even grouping of controls, but just reasonable. And then it's up to the courts, which of course no company likes, but that's just the way it's being done. We're probably in sort of an intermediary period where these things are going to be sort of hashed out in the courts more and more going forward. Privacy rights, again, the Cal CPA gives privacy rights that are similar to what are given in the GDPR. Businesses have to maintain a special site for California consumers. The website has to list all categories of PII collected. There must be a request page to request the sources of information that the data was collected from, the purpose that they're collecting information, the categories, et cetera, et cetera. And so it has like these sorts of rights built in, and you have a right to access the information. And that's sort of California CPA, just sort of a watered down, not so watered down version of a GDPR. It's fairly strong, but again, not quite as strong as the GDPR. Next slide.
Break, but it's been an hour into the session. Do we need to make a couple of minutes break?
Yeah, maybe it could be a good idea to have a 5-minute break. Is that okay, Keith, for your pace with the presentation?
Yeah, that's fine. I'm going to get through as much as I can. Mm-hmm.
Okay, then I guess it's 8:20 here in the Netherlands. We can have a break till 8:25. Is that okay?
Yep.
Yep. So everyone, there is no problem with the slides. We're going to be on a break for the next 4 minutes. Maybe you would like to grab a coffee or a stretch before we continue the presentation. Thank you. So I guess it's 2025. Maybe we can start shortly. So Keith, maybe we can restart the presentation if you don't
Sure.
mind.
Yeah, whenever you're ready. You ready? Okay, sure, no problem.
I think we should be like 2026.
Okay. Okay, so again, just coming back, this is the California recent cybersecurity privacy law that went into place. Again, it's just more things about selling PII, when you can sell the PII, categories. You have to give sort of information to people about what you're doing with your information, and you have to have an opt-out, right to opt out. Don't sell my personal information. Minors, you cannot sell, and minors is anyone less than 16. You can't sell any of their information unless they actually explicitly opt in. So that's California. Next slide. Um, right, and this is just more built into the California law, where if somebody doesn't want to go along with what you're looking to collect, you can't take it. You can't discriminate against them. It's similar to GDPR. As far as the GDPR is when you're giving actual consent. It's sort of the same thing here. Like if somebody doesn't consent to you taking their information, you can't deny them goods and services or anything like that. It's similar to GDPR. Let's see. These are minor details here.
But do we have the right to be forgotten, or basically the right to delete your information within the California Privacy Act?
No. You do have, it's qualified. Go back to the next slide, previous slide, Yana. No, the previous one. I'm sorry. So go two back. Okay, right. Right. Yeah. No, it's you wouldn't have a right to do any of that. You just have a right to know about it and to stop them from sharing it, but you don't have a right to actual deletion in California. Yeah, that's a California law. Now there are some states where there is such a right to deletion. I believe the Massachusetts law, which we're not covering in this one, you do have a right to have the info deleted, but not under California. Next slide. Sorry, next slide. One more. Okay, so we just went through all the actual statutes, right? This is statutory law of the federal government. I gave you a couple examples of state laws, the New York state law and the California law as well. Just sort of going through. I'm running out of time, so I am going to have to pick up the pace. I apologize about that. But under the common law, just to go over this, like this, if you're a private citizen and there's been a data breach, or a company is not doing what they're supposed to be doing, or they're taking private information or sensitive information and they're sending it out, you could possibly have a cause of action under the common law for a negligence case or a negligent misrepresentation, etc. So negligence, which is probably what most people think of when they think of like a breach of security, is just that there is a foreseeable injury to an individual. You have a duty under the common law to protect people's information, protect the privacy of their information. So when you don't do that, you're probably being negligent, right? And that's, of course, a question of law. In the United States, this is very hard to win. There's this weird sort of wrinkle in the law that says it has to do with person or property. There's sort of a very literal interpretation in the common law. So foreseeable injury, to an individual, generally it would have to be a physical injury is what you're talking about, right? Or something that affects the person or their property. And so you have this information doesn't really come under that, okay? That's how some courts are seeing it, or most courts even are seeing it. So it's extremely hard to bring a negligence case in a cyber breach incident in the United States. You have better luck for negligent misrepresentation. If you said to a client, "Oh yes, we have ISO, we're ISO 27001 compliant," something like that, and we have really good cybersecurity controls, and your data is safe. And then it turns out that you have none of that, and that you affirmatively lied. You could have a suit there, a private suit, or even a mass tort suit, or a class action lawsuit. Under that theory, there's always good old breach of contract, where you had an agreement where you were going to keep my data safe and protected, and now you didn't, and then according to the terms of the contract, you breached the contract, so now we're going to sue you under breach. That's one way you can win. Of course, it's always hard because even in a breach of contract case, unless you specify the damages, right, what we call liquidate damages, right, what the court is going to do is say, well, what damage did this actually cause? And damage to people's private information isn't always easy to find out, and it's not always easy to prove either. So even if your information got out somewhere and it's on the dark web, it's extraordinarily hard to trace that information got out from that breach, right? So all these things are very hard to prove from just even a causation point of view. You know what I mean? And then what is the actual damages for somebody finding out about some you have some sort of health problem, right? Even an embarrassing health problem, right? Like what exactly are the damages there? It's not always easy to determine. So what I say to some companies when they're or what we do here at Digital Edge is that when we go into contract with the company and they're going to be housing sensitive information, we will put the damages in the contract, so that if you have a breach, there's a specified amount. We don't have to prove that amount of damage was caused. All we have to prove is that a breach happened. And then at least that's what we could do under the common law. I do not know what the law is like in the Netherlands, but we can do that here. One that's actually used sometimes too is breach of implied warranty. You have an expectation under the common law. You have an expectation that a product that you have or a service that you're using has a basic expectation of fitness for its purpose. So you could sort of bring suit under that. There are cases you can bring under common law for invasion of privacy. You have to prove that a company published private facts about you that are offensive and not of the public concern. So this would be something you say, okay, well, if it's embarrassing, we could sue under invasion of privacy. Again, this isn't even always a winner, because the question surrounds what does published mean? Do you have to intend to publish, or can it just be a breach and something gets published? Are you responsible for that? So that's not a very strong one either. And unjust enrichment is sort of in the United States, and I think really all the common law countries, this is called an equitable remedy, from the old courts of equity in England, which I believe they still have courts of equity and courts of law separated in England. Anyway, under equity, what this means is that, well, if somebody benefited, all right, they benefited, they gained a profit from your personal information that they shouldn't, under fairness, have gained, you are entitled to be compensated for that, the fair value of that benefit. So that's it. Those are the common law causes of action that could possibly be brought for cybersecurity breaches. Your best bet, if you're looking to protect yourself, is to build into the contract a liquidated damages clause, so that if you have a breach, you're going to pay me X amount of dollars, and that's all there is to it. All right. The next best one would probably be negligent misrepresentation. All right, next slide. Hi, Yana, can you put next slide?
Okay, it seems we have lost Yana.
No, I was just going to ask, is it the same situation again? Well,
Can I switch over from Yana?
Yeah, that's fine.
sure.
I'm here. I don't know why it's not working.
Okay. Here, can you see my screen now?
Yes, we can.
Good. So, is it the one which you wanted?
No, go forward 2 more. There we go. All right, so I'm just going to finish up here telling you guys about things you probably already know quite a lot about. The GDPR, or at least how Americans see the GDPR. Let's say it's how Americans see the GDPR, right? Mix it up a little. So the European Union, as you know, has this comprehensive GDPR. They consider privacy to be a fundamental human right. You have the right to be forgotten, which is to say the right to be deleted from their database. You have the right to access your information. You have the right to change your information if it's incorrect. You have this whole list of rights that people get, and U.S. companies are aware of this. And when they do business in the EU, if they're controllers, right, they must follow those regulations. Next slide. All right. So, yeah. So, look, here's the thing, right? The EU, this is another jurisdiction question, right? Let's say you're working for a company in the United States. Does the EU apply to my company? This is something that a lot of companies in the United States have to grapple with. The EU, if you read the actual text, if you do like a textual reading of the EU's jurisdictional grab or mandate or declaration, if you're offering, if the data it processes, a company, right, is related to either the offering of goods or services, irrespective of whether a payment of the data subject is required to such EU subjects, or the monitoring of EU data subjects' behavior to the extent their behavior takes place in the EU. Okay, so the big thing here is offering goods or services, right? So if you're offering goods or services to an EU data subject, well, then the EU says that they have jurisdiction. The question is, offering, right? What does that mean exactly? If you just do, someone just said, yeah, that's correct, Michael, that the privacy shield is not affected. That's correct. So if you just do a textual reading, you say, well, geez, that could be my company, right? I have a website out there. I offer apples for sale. to anyone who wants to buy them. And if those people are in EU, well then, yeah, I guess the GDPR must apply to me. Well, no, that's not really what this means. The European Commission has sort of given more guidance on what this means, because I mean the truth is no American court is just going to allow enforcement action to be applied in the United States, just because the European Union says they have jurisdiction in the case, right? So the European Union, what they did is they've offered some guidance on what offering of goods means, and it's really just holding out with some specificity. So if you're a company in the United States and you're holding out to, you have euros, let's say, as euro amounts on your website, right? Or you have a dot, IE, or something like that. For, let's say, you have a site based in Ireland or some other EU country. Okay, well then yes, you are probably holding out. But just the fact that an EU citizen goes on your website does not mean that you are necessarily under the jurisdiction of the EU. I usually leave this to their attorneys to decide for themselves what they want to do, is if they want to consider themselves part of the GDPR jurisdiction. For smaller companies, so far, right? They have not gone after companies that don't have a large European presence, right? It's never really been tested, even still, this jurisdictional power that the EU claims to have, right? It's never known. No one's ever gone to a United States court and said, well, this is our judgment against such and such company, and now we want it enforced on their assets here in the United States, and I need you, American court, to approve it. This hasn't been done. And what they've been doing is sort of going after bigger companies, the big American multinational companies that have assets in the EU that can be, attached to any sort of action by the EU. So they have to really follow by the GDPR. It's clear, A, that they do come under the GDPR, and B, it's easy for the EU to enforce judgments against them, right? So, but for smaller companies in the United States, this hasn't really been tested. This jurisdictional power that the EU claims to have. So GDPR, as you know, it applies to all industries. It's got security controls, breach notifications, privacy rights. Again, it's just reason. So it's got it's got all three of them, and all three of them are pretty well defined as far as breach notification and privacy rights. Again, security controls, they just sort of leave up to reasonable. But this is by far, the most comprehensive law in the Western world. I'll put it like that. I don't know exactly what's going on, in the Far East, but in the Western world, this is about as good as it gets. Again, the United States isn't anywhere near doing something like this. We're not anywhere near doing something that's a pale imitation of this. So you have these reasonable cybersecurity controls in place. You got to notify the government authority within 72 hours security breach, or if it's a high risk, you notify individuals without undue delay, whatever that means, and that's going to mean whatever the Data Protection Authority wants it to mean if there's ever really a problem. So you got restrictions on PII collection, right to access, control, PII, all these great things. And you have the government data protection authorities of the several European Union countries in charge of enforcement. And then I'm sure you guys know all about the max penalty is gigantic. 20 million euros, or 4% of global annual turnover, depending on severity, whichever is higher. I mean, this is This is amazing. I mean, not to say that the United States doesn't have even bigger fines, but it's just amazing to see it actually in writing in a statute like this. Now, I just bring up, the British Airways case, 183 million pounds in 2018, for a breach they had. And the reason I sort of bring this up is not the 183 million that I put in big letters to scare everybody. This was actually taken down to 20 million pounds. And the reason it was done, it was lowered so much is because British Airways, they followed their incident management procedures correctly, right? And B, they cooperated with the data protection authorities in their investigation. So it went from 183 million was the initial fine sought all the way down to 20 million. So, look, if something happens and you get breached, just as a practical matter, whatever authorities going after you, whether it's the American authorities or the European authorities, they're going to find there was wrongdoing. Okay, it's almost impossible that my mind would be blown if they actually said, "Oh no, you guys did all the right, reasonable things. So even though there was this breach, you guys are in the clear." No, that's not going to happen. Okay, they're going to find things. Okay, pretty much no matter what you do. The trick is to do as much as you can so that when they find, so that the fine goes down as much as possible. Okay, that's what we're looking for here. And that's what British Airways. Look, they were breached. They admitted to it. They knew it. They allowed access. There's a full investigation. They did the right thing when the breach happened. They followed their policies and procedures, and it was a much less burdensome, tax on them, essentially. Next slide.
Keith, I just wanted to make one additional comment about jurisdiction. Because, well, from the practice, what we see is that for American companies, it is really up to their own decision, up to their lawyers, attorneys, what they're going to advise. Because consider even a large retailer that doesn't have any European presence, let's say Best Buy, who is big in Canada, US,
right,
Mexico, I believe. There is no European entity. There is no European presence, but they still might have European citizens registered as user accounts with them.
And Europe might have jurisdiction. That they might. It depends. Like if they're going in and they're offering their services specifically to Europeans, right? And it's in, it's a site, let's say that's in euro. So instead of Canadian dollars, it's in euros, right, or something like that. Or it's like, hey, citizens of Netherlands or Netherlanders get 10% off, or something like that, and it's directed to them. Then technically the EU does have jurisdiction under their own laws, and the United States would probably agree that the EU has jurisdiction. So that means if there's an enforcement action against that store in the United States that's holding out to the EU, right? There would be enforcement action in the EU. They'd be fined, let's say, $1 million. Then they would take that fine over to the United States, a court in the United States, and the court in the United States would have to determine for itself whether that court thinks that the EU should have jurisdiction under the laws of the United States as to what we consider them to have jurisdiction. And if that's the case, where it's in euros and they're giving like discounts to people of certain EU countries, then yeah, they'll be able to enforce that judgment here in the United States. That European judgment could be enforced in the United States through an American court, and that's how that would work.
And just final note, from real life examples, some of US companies which do not have European presence, but they are planning to, they do tend to go and start GDPR compliance processes, and some of them go to the extent that they will separate their data environments, planning for European launch. But as of now, It is more a political debate, and I would say it's not the something which has to be mandatory for U.S. Companies. Would you agree, Keith?
Generally speaking, yes. Yeah, for mid-sized small companies, generally, yeah.
Okay, so
Yeah.
now to the next slide.
Okay, so this is the EU-US Privacy Shield. It was a big embarrassment for all involved, right? We were talking about this earlier. Yeah, so if you're going to transfer Europeans PII outside of the EU, you have to come under one of, okay, so there's 4 different ways you can do it. The nation to which the data is being transferred has to be deemed by the EU, by the European Commission to have adequate protection for PII. The U.S. is not one of these countries. All right, that's it's kind of embarrassing, sure, but it is what it is. Another way you could do this is the foreign company has adopted binding corporate rules and imposed significant restrictions on PII. Fine, that's really what people are doing now. They're just basically protecting PII with corporate rules and doing it that way. That's probably the way they're going to have to continue doing it. Another way is the foreign company agree to handle Europeans' data pursuant to a standard contract clauses that have been adopted by the EU. Yeah, this isn't done as much, but it can be done. There are standard contract clauses that exist. Now, here was the one that we were trying to do between the United States and the EU. This is the Privacy Shield. Foreign company agrees to binding and enforceable commitments regarding safeguards and data subjects' rights via an improved code of conduct certification mechanism. That's Privacy Shield. So, next slide. Right. So this was negotiated and approved in 2016 between the EU and US. It applied to all companies. It had security controls, had privacy rights, and all the things that would be necessary. And this was enforced by the FTC. And it was a $43,280 violation per day for continuing violations, which is pretty steep. Because what you have here is an aggregate violation, so it could be like $1 million, say, and then it's per day. So, it's very steep penalties, but of course, none of this matters because next slide. It was struck down by the EU court in 2020. It's no longer valid, and generally, American companies will just have binding corporate rules that make them compliant. And it's because the United States is watching you. And I got that graphic up there. It's Uncle Sam. I don't know if you guys are familiar with Uncle Sam, but he is sort of the personification of the United States. And he sure is watching you. So there are negotiations for a replacement. It's unlikely, like I said, the whole thing was struck down because of the spying, and the United States is probably not going to. I can't imagine we're going to be changing our position on that anytime soon, though I always keep an ear out. I haven't heard anything lately. So,
Keith, may I ask a question?
Sure.
Because I'm working quite a lot with hospitals, and there's a big discussion always if we can trust in this discussion to store health data from European citizens in the US. Would you think it would be safe?
Oh, health data?
Yeah.
I'm hesitant to say anything, to be honest, because here's the thing, right? Nobody really knows exactly what the capabilities of the CIA, the NSA, or the civilian contractors, intelligence agencies are. I would think that health information isn't something that they'd go for. That's certainly something they wouldn't want to, publish or anything like that. But as far as the capabilities, nobody really knows. And we have Edward Snowden, I used to have a whole segment on Edward Snowden in here, and I was told to take it out. But we don't really know. I mean, I can't really give you yeah, probably it's going to be safe. It's going to be fine. I mean, we have strong rules in the United States for healthcare, for protecting private healthcare information. From that, I mean, you're worried about the United States government, and I can't tell you what the United States government's going to do.
Oh,
Oh,
can I just remind everyone that we have another 5 minutes till the end of the. Sorry, Gilbert, I didn't mean to interrupt you, but just a small reminder. And the other fact is, maybe the answer should be split into two parts. If we are talking about a state, or let's say, a state-funded kind of. Is it secure, or are we talking about commercial? Because also I assume that part of Gilbert's question is about the commercial side of things and not just the government side of things.
Yes, so this is Slava Digital Edge. So from practical perspective, as Keith mentioned, there are some strong technical frameworks and controls with HIPAA, high trust, which do require companies to know what is happening with the data, where the data is, where it is transferred to, who has access to this. So technically, it should be safe, but there is always this political side to it where you don't know, is it going to be safe from the government, from regular folk, from data breach. It should be safe, and US is making all the effort to ensure that the PHI data is regulated, controlled, and there is the responsibility tied to handling with this handling PHI data, including criminal responsibility in some cases.
What I always understood is that there is a difference between the rights of U.S. citizens in the Americas and foreigners, so that privacy of data for European citizens is just data and can be sold and is less protected than from U.S. citizens. But that's not completely clear to me.
That's not
No.
exactly true.
No, that's not true. It's going to be protected the same way under HIPAA.
So yeah, under HIPAA, under high trust, there is no separation between U.S. citizens or non-U.S. citizens. It is PII, it is still PHI. So there is no separation. So from technical perspective, from implementation's perspective, the data would be safe.
Right. Yeah.
Okay, thanks.
There is a question coming over text as a follow-up. Was that any different when Privacy Shield was still there?
Was what any different?
I mean, like, was any of the discussion happening about like the privacy of
Are you talking about
records?
government?
Yeah, I guess that question is. Michiel, would you like to unmute and maybe follow up on your question, please?
I think I can at least try to give an answer. So discussion was always there, and the Privacy Shield was just aimed to put some legal perspective into how the data transfer is happening between Europe and US. So it was an attempt. It was a really nice attempt for that time, but the discussion was always there. And GDPR is actually an excellent example where that discussion led to. So European Union just decided to take the matters in its hands.
Okay.
Does this answer the question?
I guess so, but Michiel, yeah, we got a confirmation over text. Yep. Thank you.
Oh, great. All right. Listen, if we could just jump, I'll just finish up real quick. I think I only have a couple of slides left. Yana, can you just go to the next one? Or I'm sorry, Slava. Okay, so look, just why it matters here, right? I mean, we all know you guys are in ISACA. You know that we're no longer the way it used to be, where you can just sort of get away with some malware protection and a firewall. Things are being regulated very seriously now. The GDPR, it could be a public relations nightmare. There could be criminal violations, for goodness sake. There's the power to literally destroy companies, both in the United States regulators and also under the GDPR. So this is why it matters. It's very important. It's always really been important. We're starting. I mean, we realize now, just how important it is. But the impact is just getting bigger and bigger and bigger. Next slide, Slava. Okay, so this is the last slide. So, this is what I just tell people. Look, when you're talking to executives at the company, you just got to focus on the risk. Let them know there's a real risk to the company, that the IT field is changing, it's becoming more compliance oriented. Just like say with finance or healthcare, let them know that the vulnerabilities that are in place the company has. They need to know exactly what non-compliance with laws could harm the company. There could be fines. It could be real reputational damage. If you have like a nice executive, you could even say how it's important to protect people's privacy in its own right. I would say don't exaggerate the cost of bringing your systems into compliance. Determine what steps need to be taken. Just get a real time and cost associated with the undertaking. You want to be clear. They want to know that there's risks, that these risks are serious, and that you can bring things into compliance, reasonably well using a reasonable amount of resources. That's not going to, bankrupt everybody. And just make sure they're aware of the benefits. And that's it. I mean, that's pretty much. That's my module for today. I don't know. I mean, I know we're out of time, but I mean, I'll be happy to take other questions.
I think we do have a couple of minutes for more questions. So, gentlemen, please raise your hand and unmute yourself and shoot your question directly to Keith. Any questions? If you would like, you can also text if you're having problems unmuting yourself.
And another thing, I don't know if you were told this, but we usually make our slides are available, for whoever wants them. We give it right out, and just to have for your records, so you just keep there, and it could help you, guide you, whatever you want to do. So.
Well, we mentioned that at the beginning, and I think Debbie from our side would be handling this.
Okay.
So I think Thomas sent us a question. Might the 20 MIO cause calculative approach to cybersecurity detection? Maximum 20 million fine in the EU. Thomas, can you maybe unmute and ask your question easier, because I feel it's not very clear.
Yes. Can you understand? Can you hear me?
Yep, I can hear you.
Yes, sir.
Yeah, well, you said that like the British Airways case, there was a fine of maximum 20 million euro for not complying to GDPR. And if there's a max of 20 million fine and you are a large company and you are an executive of it, might it be that they are in a way economizing on this maximum of 20 million? When they have to protect themselves against breaches, but the 20 million for them is not too much. Would it? Yeah. Can they say, well, okay, what's the risk? How much is it cost? Is it going to cost me to a maximum? And how much effort do I have to put into in order to protect myself?
Right. I mean, yeah. I mean, the answer is yes. Right. You would have to. I mean, you do know that the maximum is, like 40 million or 4% of turnover, 25 million total. Right. So it's just going to be hard when you're doing the calculative approach to what exactly the number is going to be, because the EU has a lot of flexibility. Right, because even with the British Airways case, right, that started out as almost a couple £100 million, right, yeah. and then it was lowered, 150 million pounds low. I mean, so it's hard to say, I mean, and then figuring out, there's just so many different variables, because you got to figure out, like, okay, well, each different type of violation is going to carry a different type of fine. Obviously, if it's something more egregious, it's going to be a bigger fine. If it's something less egregious, it's going to be a smaller fine. So it's just it is difficult to do it that way. It would be difficult, because I mean, look, the EU, if you're not doing something really egregious and you really just don't care, and you're even intentionally doing things that are harmful, obviously, they can pretty much destroy your company, right? 4% of turnover, or something like that. But that's, never really going to happen. If you look at the cases, they're never, going the full amount, right? So, you'd have to kind of get an idea and sort of come up with a number, just based on sort of using common sense, and reading through the type of cases that they take, and kind of the fact-specific circumstances of those cases. So it's really difficult to do.
Okay. Yeah. Okay. Thanks for the answer.
Sure.
And thanks for the presentation, by the way. Very interesting.
Sure. Thank you.
There is a very interesting question in the chat about the level of GDPR. Would you expect that level to be matched by US regulation in the near future? I would think well, there is a standard from ISO 27701, which has a lot more chances to get adopted within US and internationally, rather than GDPR-like level of requirements. So in US right now, California Privacy Act is probably the strongest one, right, Keith?
That's right. Yeah, that's right, Slava. Mm-hmm.
And it's still nowhere. Well, it's not as strict as GDPR.
It's watered down for sure. Yeah, I mean, like Mike says, I don't know if Mike's on the call right now, but in the United States, the question isn't like how strong privacy rights should be; it's whether there should even be privacy rights. We're still, there's still people who are against that. So, yeah, that's not going to come for a very long time.
Yeah. For the sake of time, I would like to thank you for the great presentation. We're looking forward to the next part, which, just to remind everyone still on the call, that it's on May 26th, the same time. And I would like with that to, let's say, conclude our today's meeting. Thank you so much for attending.
Thank you.
Thank you, guys.